May it please the court, my name is Donald Vowell, representing Mr. Dunn, the appellant. And I do request 2 minutes of rebuttal.
2 minutes?
2.
That'll be fine.
All right. So, we have a case of intentional misrepresentation or fraud in the location of the septic tank, proved by clear and convincing evidence and with reasonable reliance. All this is found by the trial court. So I'd like to focus on 3 things. First, how is rescission and restitution supposed to work? Second, the question of punitive damages. And third, the remedies to be available on remand. So as for rescission and restitution, the court awarded the sellers, who were the wrongdoers, misrepresented the location of the septic tank, rental value of $900 a month for the 11 years, for all of the 11 years since the day of sale. But at the same time only gave the purchaser, who was the innocent purchaser, interest on the purchase price for 3 of the 11 years. Now, and why did that happen? Because the purchaser did not mitigate its damages, as the trial court put it. Now, so first, I think that's the wrong principle. In rescission and restitution, it's not really a matter of damages. It's just a matter of undoing the transaction. So if the seller gets rental value for 11 years, I think you have to give the purchaser interest on the purchase price for the same period. Otherwise, the seller is getting a free ride. That's the terminology the court used. Now, so what did this what did the plaintiff supposedly do wrong? Well, what was he supposed to have done to mitigate his damages? Well, spend another $50,000 to $100,000 to move the septic tank from inside the house to some other location. So he's just spent $302,000. That's his life savings. And the court says he's supposed to, or the court said that he should have spent another $50,000 to $100,000 to mitigate his damages.
Was there proof in the record that there was another viable location for placement of the septic tank?
No, there wasn't. In fact, the defendant's expert said, he recommended tearing off the house, the lower level, because he wasn't sure that the lot would even support a septic tank, in another location. So no, there wasn't any proof that was even possible. But that's what the court, that's where it came down. So and this is all because the other side has misrepresented the location of the septic tank. They're in there at the walkthrough. The court found this. They're in at the walkthrough, and so Mrs. Vukodinovich is out there, and Mrs. Dunn, or then Ashworth, and the realtor, Ms. Lohoff, and so where's the septic tank? And Mrs. Vukodinovich says, here. They go out on the deck. It's out there in the yard. Well, it was under the pool table, and she knew it. So it's intentional misrepresentation. Now, so the way rescission and restitution is supposed to work, the purchaser, the next problem is the improvements. Mr. Dunn spent $50,000 improving the property. And so you're supposed to get credit for the value of the improvements, or surely at least the cost of the improvements. And the issue going on here is there's such a long time period between the sale. It has been 11 years since this property was sold. So it's supposed to be measured as of the time of rescission. But the court said, the trial court said, we have to measure from the day the improvements were made. Well, that was 10 years or 11 years before. So Therefore, the plaintiff's expert's proof was rejected. And plaintiff is awarded no damages for the improvements to the property.
Excuse me for interrupting, counsel. The fact that the appellant made these improvements to the property, did that have any bearing, according to the trial court, on the determination that there was a failure to mitigate damages? Was there any connection there at the trial court?
No, Your Honor. I don't think so. If I understand the question.
Yes.
The improvements were like a retaining wall, a building, also, but it had nothing to do with the septic tank. And I think probably when most of these improvements were made, they didn't even know that the problem. So the other side gets.
Excuse me for interrupting. So the proof in this case is that all of these improvements were made before your client even knew that there was a problem?
I cannot say that's true. I think it may be true, but the timing of those improvements is I think that's true. I'll just put it, kind of leave it that way. I'm not, if it's in the record, I think it doesn't. I think that's the way it happened.
Thank you.
So the other side gets the property back with this $50,000 worth of improvements, which now, as on the day of trial, was worth $129,000, but he doesn't have to pay for them because the mitigating the damage. So the other question that relates to this, their experts said that this is a problem that, quote, must be corrected. Obviously, that's true. And that the best remedy would be to demolish and remove the lower level of the house. That's their expert. And for his opinion of the rental value of $900 a month, he assumed that the lower level of the house did not exist. Just assumed it out of existence, assumed there was no problem. With no problem, this property, and take off the lower level, you can rent this property for $900.
Was there any proof that proposed modification was even a viable option as to the integrity and structure of the house? I mean, did anybody put on any proof of that?
No. That's what he said, it's what he said. He said the best remedy, I think that's a quote, the best remedy is to take it off. And
any proof as to what that would cost?
no, there wasn't. Untold cost. Who knows what that would cost? And then you have to, but that's what the witness said. And yet his testimony was accepted. Our testimony was rejected because the judge said he didn't do any market research. Well, his testimony was that, well, this property's not rentable. It's got the septic tank in the house. You can't rent it. And so the judge, disregarded that because market research does not bear on that topic. So anyway, so you lose, that's 40% of the house. The guy's testimony was the best remedy, you lose 40% of the house. And, you just paid $302,000 and the expert thinks you're supposed to tear off 40% of it. And he seemed to agree. He said that you have to do that the property in its present condition was not rentable, just like our expert said. So the second question I want to deal with is punitive damages. That is for the purpose of punishing a wrongdoer or deterring the wrongdoer and others from similar conduct in the future, of course. The statute maliciously, intentionally, fraudulently, or recklessly. But the trial court said that, quote, punitive damages is to punish a party for the purpose of this practice ceasing. And that's why the court did not find punitive damages. I mean, of course it had ceased by the time they got to the court. It ceased by the time they walked off the property. And so this is, it's a one-time event. It was over. Like most fraud, it's done. And so there was no punishment here and no deterrence. If this is how it works, people would do it that way every time. So now that brings me to the remedies available on remand. At the trial, we asked for rescission. And if the trial court had properly applied the principles of rescission and restitution, that would not have been a bad idea. Or if it happened when we asked for it, that would not have been so bad. But the trial court then, sua sponte, reopened. The case was over. Sends an email, reopens the case for the benefit of the defendants, to allow them to claim this rental value that they had not put on any proof of. And the election, the decision doesn't happen there were 3 more days of trial, and the decision doesn't happen until 2 years later. And that's about 3 years now. And it's been 11 years since the property was sold. And we're talking about rescission. And I think the remedy of rescission and restitution really breaks down after such a long time. It really gets hard. Maybe remanding for whatever remedy may be appropriate would be the best and most appropriate way to accomplish whole justice, which is what the cases say we're after, or a just result. So we have a lot of moving parts here. No reason to tie the court's hands as to what is the best remedy. Now, I'll mention one case, the Ingram versus Beezer Homes. That's this court, 2003. It was a rescission case. The court faced a dilemma as to what remedies should be available on remand. They laid out 4 remedies, talked about each of them, make them stick with rescission or whatever, But the remedy that the court chose was remanding to allow the parties to reopen their proof, with the trial court to consider whether to grant rescission, to reconsider whether to grant rescission. And that is when you're supposed to make your election anyway, right? After the close of proof. You don't have to make so early in the game. So I mentioned one final point. The other side here has already gotten a second bite at the apple. The judge, sua sponte, reopened the case to give them a chance to prove.
Do you have any law saying the judge couldn't do that?
No, it's discretionary. But the law says, as I think I quoted in our papers, you're not supposed to do it as an advocate for either party. And that's almost what happened here. The judge said, they didn't prove their there, let's get this case reopened. And so it worked completely for their benefit. And so, which would have been fine if the court had then applied all the principles of rescission and restitution correctly. But the way it turned out, it was not so fine. Thank you very much, Your Honors.
You have your time for rebuttal. We'll hear from the appellee.
Good morning, Your Honors. May it please the court, Brett Mays here of the Johnson City, Washington County Bar. As you could tell from the record, this is quite a case with a little bit of a sordid history. I'll be frank and honest with you. I came into the case at the very end stages of it, as this started about the time that I was being a second-year associate lawyer at a law school, and so it has quite a long history. And I do agree with the premise that the time has made this difficult to evaluate. However, I would submit to the court that the time that it took to get to a final order for the court, or the trial court in this matter, was of no fault of really either the plaintiff or the defendants. It's just the way things kind of worked out and shook out, and sometimes that's just how things go. I will start off by saying that we keep hearing this idea of the defendants got a second bite at the apple. Everyone got a second bite at the apple. The trial court reopened proof, which is in his sound discretion to do, because he was trying to judge this matter on the basis of equity. The plaintiff, at the very beginning of the first hearing in 2020, made an election to pursue the remedy of rescission. I don't know why. I can't go back and evaluate that decision, but that is the decision he made. He pled in his complaint for either damages not to exceed $50,000 or alternatively for rescission of the contract. In doing so, he places the trial court in the position that this is an equitable relief and the judge has very broad discretion to look at the facts, the circumstances of the case, and award relief and fashion it in a way that he believes provides justice for the circumstances. I think the case law is very clear on that. We've cited that over and over, and I'm not going to belabor that point. But while the plaintiff would prefer, I believe, to go back and start over and retry this case again, I don't think that's an appropriate option for a number of reasons. First of all, just to point out, the standard of review here, we're talking about an abuse of discretion again. While obviously the conclusions of law that the trial court had were de novo, as the Court of Appeals offers the trial court a great deal of wide level of discretion, sitting in equity, judging testimony, facts, circumstances, and issues. And I want to come back to this phrase that we cited in our brief from the Hickson case. If the decision is within a range of acceptable alternatives, this court will not substitute its judgment just because it may have chosen a different alternative in that situation. With regard to the issue of allowing additional proof on the fair market rental value, as pointed out earlier, Tennessee courts have consistently held that permitting additional proof after proof is closed is solely at the discretion of the trial court. I would cite Simpson 810 Southwest 2nd 147 for that proposition. And not only is that the legal conclusion, in this instance, both parties had the opportunity to do that. This wasn't just opened for one particular issue. The trial court also heard testimony regarding mortgage interest, real estate taxes, homeowners premium interest, which was awarded, and also asked the plaintiff's counsel directly, is there any further proof or evidence to be submitted regarding the value of the improvements made to the property? To which I believe, not trying to quote directly, but the record indicates that the plaintiff's counsel stated, no, I believe we're just going to rely on prior testimony from the first hearing. Secondly, with regard to...
Excuse me for interrupting.
Yes, Your Honor.
With regard to the issue concerning the improvements, why should the plaintiff not be given credit for the value of the improvements made in this case?
I would submit to the court, and this is what I argued at the final hearing, the plaintiff has not sufficiently shown what those improvements were. The record indicates that there was one statement regarding about $50,000 in improvements made. And that's all of the evidence that I can point to in the trial court record that shows what these improvements were. No testimony regarding what exactly was done. This is how much it cost. This is what we bought at Home Depot. This is how much we paid the contractor to do this. And then further, when the trial court gave them what I would say a third opportunity at this final hearing to put on proof, because the issue was reserved in the first order. And so we have this final hearing, and the trial court, again, allows them to put on an expert. The expert offers testimony regarding the improvements, and then was directly asked, can you, to a degree of reasonable certainty, say that the value or the increase in the value of this property to today, which is when he measured it, because appraisals are spot, a point in time we're measuring the value of this property. And so he measured that, and he said, okay, there's this these are what the improvements are that they told me, and this is how much they improved the value of the property. And so he was asked, can you, to a reasonable degree of certainty, state that the increase in the value of the property that you've proposed is due to those improvements and not just the natural forces of the market over the course of a decade? And he said, no, I cannot, as I sit here. And so while I do agree with the premise, and the case law clearly states that in the case of rescission, the plaintiff can recover for the value of his improvements, I think the plaintiff failed to prove his case in this situation, and he was offered multiple opportunities to do that and did not offer sufficient evidence, and that does not now constitute a reversible error to send it back to start the whole thing over again.
Was there proof as to when the improvements were made?
When you asked that question, I wasn't really sure either, and I was trying to look back, and obviously I didn't have time to go through the trial court record just now, but I believe at the final hearing there was some testimony offered by the plaintiff, and there may have been a time period there. I don't believe it was right at the time of the purchase, but I cannot sit here and say with certainty whether it occurred before the 2013 event or it did not, to answer your question.
Thank you.
On the $900 of fair rental value, that was $900 as of when?
He measured that $900 as of, I'm not sure, Your Honor, but if my best guess would be just based on that point in time when the hearing was occurring. But I believe he tested.
There was no proof as what the rental value was 13 years earlier.
I think, I'm not sure, Your Honor, to be honest with you. Part of me wants to say that there was some discussion about that was kind of an average figure, but I'm not entirely sure on that, so I don't want to misrepresent that. I will say that this is a home on a lake. That's a pretty low rental value, definitely by today's standards.
Were there many other homes on the lake with a septic tank under the pool table in the basement?
Maybe not, but a lot of things got
Probably
grandfathered. Maybe not, probably not. But there's a lot of things that got grandfathered in back in the 60s and 70s.
Counsel, I guess here's where I start with the overall problem in this case, that the trial court found your client intentionally misrepresented where the septic tank was. Correct?
There is some language in there about innocent misrepresentation, and I'm not sure, to be honest with you.
Okay. I think the trial court did.
Okay.
If that's being so, why, and the trial court grants rescission, why did it allow your client to keep the benefit, to have that money for what was it, 13 years, and award interest for only 3 years?
Well, Your Honor, the trial court mentioned this idea of mitigation of damages and whether the plaintiff should have taken some sort of action to put the parties in a different position than they were by 2020.
Well, but the trial court decided to do rescission.
Yes, that's correct, Your Honor.
So once the trial court decides on that rescission is the appropriate remedy, you're no longer talking about mitigation. I mean, are you talking about what damages are there to be mitigated?
Well,
because the damages are not going to be awarded on that.
And you're right. We're not really talking about damages. We're really just talking about what does equity require at that point on behalf of the party who identifies the problem.
That your client intentionally misrepresented.
Correct. And then what do they do at that point in time? Do they do nothing? And I think that's what the trial court focused on.
What did your expert say could have been done, should have been done? Was it your expert that testified?
Well, the plaintiff had two experts testify, one at the 2021 hearing and one at the last hearing. And then, yes, the defense did have an expert testify, and I believe the representations offered by the plaintiff are correct on he had recommended, just unfinishing. The basement had basically been finished as a walk-in area where if you came out of the lake, you could shower and get get cleaned up before you went up to the main level of the house. They don't connect. It's not necessarily what I would have called improved to the, a point of that it'd be considered livable space on the property. But it was basically, the idea was to create this area where they could go after they got out of the lake so they didn't come in to the main house.
You say it wasn't livable. It had running water and electricity, didn't it?
Yes, yeah, I'm sorry. It was livable, but it wasn't necessarily up to, I guess, the standards of the main living portion of the home.
Had a pool table in it.
Yes.
Was there proof in the record submitted as to how long your clients owned and occupied this property?
I'm not sure if it was specifically mentioned, but they had owned it for several years, I think over 10 years before that. Moving on to this issue of punitive damages, there is some conflicting language in the order, I think, about innocent material misrepresentation, innocent mistake, things like that. Assuming, for the sake of argument, that the trial court did find them intentional fraud or intentional misrepresentation, I think that the issue of punitive damages still comes down to, we're not necessarily talking about whether the court could have awarded. It's just whether he abused his discretion in not doing so in this case. I would specifically cite to the Goodman case, which quotes the Isaacs case, which has been quoted several times in our briefs. The Goodman case was 2006 Court of Appeals here in the Eastern Section, 02678 was the case number. And that talks about this idea of finding deliberate fraud or deceit. And that goes again to this point of, was there some sort of egregious conduct that happened that would make it appropriate for the court to award punitive damages? I think the court, when the court's order, and we were quoting off of the record when we drafted that order, but he was saying that the purpose of punitive damages is to kind of prevent this from continuing to occur, and he didn't think that it was necessary in this case to award punitive damages for that reason. I'm almost out of time, so I'll just quickly say, Your Honors, on the interest on the purchase price, our brief speaks to this. That they borrowed a substantial portion of the purchase price, which is why we're having this discussion about mortgage interest. I think it's speculative to award interest on the purchase price when you're also paying interest on what you borrowed to buy the home. I know at some point the plaintiff did pay off the debt to the house, and then also on the issue of attorney's fees, we would just again submit in our brief that once he has elected to rescind the contract, he can't therefore depend on the contract to be awarded attorney's fees. Thank you, Your Honors.
Thank you. Here's the appellant rebuttal.
I think I just heard that if you pay cash at closing and get a mortgage, saying that you don't get anything at all back. I think I just heard that. But anyway, conflicting language regarding intentionality. There's no conflict. The court quoted what they said a couple of times, but he said, defendant Pamela Vukodinovich made an intentional representation of the septic tank when she knew it was under the table. That's the trial court. So there's no conflict, and it's not a matter of abuse of discretion. I mean, it's not a matter of maybe he used the wrong legal principle in applying punitive damages. It's not for the purpose of the practice ceasing. The space is livable. The court saw the pictures. It's a refinished the bathroom, bedroom, everything. It's livable. Rental value, as of the day of trial, that's very clear in the record. That's what he said. Their expert gave it at the day of trial and not otherwise. Now, the improvements were indeed done within the first 6 months or so. I think this is going to be in the record. That within the first 6 months of occupancy. Early on. Now, the council says we did not sufficiently show the improvements. The court said, quote, appliances, hardwood floor, granite countertop, finished the downstairs, put in retaining walls, remodeled the laundry room, replaced the electrical, and shored up the seawall. Nobody questioned that proof at trial. It didn't get questioned until we started this briefing process on appeal. The judge said it. No, they didn't object to it and didn't offer any proof to the contrary.
But what was the proof as to the value, not the cost, but as to the value of the improvements?
$129,000.
But did the expert say, as I understood counsel to say, that I can't really break out from that what is simply the increase in value of the property over time as opposed to the increase in value of the improvements?
Of course he said that. It's $50,000 spent in the first 6 months. 11 years later, the whole property has appreciated. That's why it's so unfair that they're going to get, the question counsel says, what was his expression? Range of acceptable alternatives. We're not in the acceptable range. We're going to send back this property. The house itself has appreciated greatly in value. The improvements have appreciated greatly in value. And we're going to pay $900 a month. That's $118,000. In return, we grudgingly get interest for 3 months.
You've used your time, counsel.
Thank you, Your Honor.
Of course, thanks to both sides. Appreciate your oral argument and your briefs.